Hi, everyone. Good afternoon. I thought that I would start today off talking about workplace romances a bit. Um, because if you're from Toronto, of course, you've heard about the news with our mayor, John Tory. So we often get questions about whether or not dating in the workplace is allowed or if it puts an employee's job in jeopardy. Um, it really is a context dependent situation. So in the event that there is a power imbalance between the two individuals, so like a manager and their subordinate employee, you're going to be a lot more likely to potentially run into issues. Um, the manager, for example, might have control over your scheduling and your hours. And if that sort of relationship goes sour, that can become a pretty big issue. It's possible always that somebody decides that it was consensual and later on decides to allege that it was not. That, of course, is going to create a lot of liabilities for the employer, for the manager, human rights violations, sexual harassment issues. That said, of course, you can have consensual workplace relationships. It was sort of commonly understood to be poor conduct and wasn't really taken very greatly, taken very positively by employers for a pretty long time. It has sort of shifted. I mean, we all spend so much time at work that it's a little bit difficult to sometimes in certain industries, especially, meet people who are outside of your field or outside of your office. So there has been sort of a shifting view towards acceptance on that front. That said, it's important always to understand what your employer's workplace policies might be with respect to workplace relationships or the requirements regarding disclosure of those relationships. Personally, I would advise that in the event that you are in a workplace relationship and it's going somewhere sort of serious, it probably is a good idea to disclose it, especially, I mean, do disclose it if it's in a policy, but even if it's not, that creates sort of a protection from any situations that could potentially arise if somebody changes their mind at a later point. In terms of managers and subordinates, or sort of people in different power positions, the manager or power person should not be someone who is in a position of control over the employee, or their career progression, their work hours, there's promotions, so on and so forth. So in the event that you were dating a subordinate at your workplace, likely one of the two of you should be moved into a different reporting structure, so that you or they are reporting to someone other than their spouse. There's also issues relating to favoritism or even the perception of favoritism, which can cause big issues for workplace morale. So that's another reason that in the event that a workplace relationship is going on, there should be sort of some clear guidelines. It's another reason why workplace policies are put in place for this. They would explain to employees sort of what their obligations are, how to disclose their relationships, and give them sort of the information ahead of time about what would happen in terms of things like reporting structure changes and so on, if a policy is, if there is a workplace relationship at play. There's no laws in Canada against workplace relationships. It really does come down to the company's specific policies. And they can set ground rules. I mean, obviously within reason. The real concern is the possible abuse of power and the possibility of non-consensual relationships. It can vary. And also pursuit of individuals while they are in a workplace environment, and especially when that is not necessarily, when the affection is not necessarily returned. You want to be very careful to understand and abide by the if you're pursuing someone in the workplace, which I would not personally recommend, you need to be very, very cognizant of the boundaries being set by that person, of the perception that you are putting out, and also that you are not making unwanted advances. Can very quickly turn into a sexual harassment situation that could become quite serious. So I guess communication really is the overarching lesson here. Communication with your employer, communication in the workplace, communication with whoever your potential partner might be. Yeah, just, be careful. I have a question from JBK from YouTube. He wants to know, or they want to know, if you worked for a company for over 30 years, you're entitled to severance on retirement. There are no severance entitlements or termination pay entitlements upon retirement. It is sometimes possible that you can negotiate something like a voluntary separation package or retirement package with a tenure sort of that long. That could be a possibility with your employer. I don't know them, obviously, or who they would be, so it's difficult for me to say for sure. But it is something that we do see sometimes. Sometimes it's sort of like it's not going to be 30 months of severance, I'll tell you that. But there could be things like continuing your benefits until they're expired, negotiating something like that in, potentially like some amount of severance pay or voluntary separation pay. You may have to resign versus retire in order to receive that. That would just be sort of for the purposes of the paperwork, I suppose. But if you think that could be a possibility with your employer, there's no harm in asking. The worst they can say is no. But no, you do not receive like severance entitlements as you would in termination if you are retiring, because it's considered a resignation and it's considered a voluntary. Ashley from YouTube as well said, if you're given notice of termination and not allowed to return to work for that period, should you still be paid for that notice period? Ashley, I'm not sure if you mean that you gave the notice or that they gave you working notice. If you can clarify, then I can answer your question. There's a question from Tanya on YouTube. Can I record meetings with my employer? So this is kind of a tricky one. The answer and my advice would always be not to do so, with the exception being something like a termination meeting where you think that you are expecting that to happen and you know that is coming, and you're concerned about being able to remember what is said and the information provided to you. Outside of that specific circumstance, and generally even in that circumstance, I would not really advise to ever record your employer. Canada is a one-party consent place. And so because of that, as long as you are partaking actively in a conversation, you are allowed to record. It's not illegal to do so. But it does present a bit of an interesting issue. And there was a case that dealt with this somewhat recently, in terms of the trust that's necessary in the employment relationship. What does that do to the trust that your employer needs to have in you if they find out that you have been recording meetings or whatever it is that you're having with them? Ostensibly, they would feel that it's a violation of privacy, even if it's legal. And it doesn't really, I think, create a very conducive environment for employment and positive employment relationships. I think one of the things to ask yourself is why it is that you would want to record a meeting with your employer. If you can just take notes, that's better. Better ways to create evidence in the event that you are, or maintain evidence in the event that you are dealing with something like workplace harassment, would be to, after a meeting, send yourself a email and copy your personal email, outlining whatever the incident or event is that you felt was necessary to record. Sorry. That you felt it was necessary to record, or that you were concerned about discussing, and send that to yourself. It has then a timestamp. It can't be altered. There's a metadata copy or whatever of the document. It's better than writing notes by hand, in my opinion, because of the timestamps, because of the sort of backups of it. While it's very rare, it certainly could be the case that somebody sits down and writes a journal by hand with all kinds of different colored pens and makes some kind of record of events. Absolutely do not do that. However, even even a suspicion raised about that can harm your credibility with respect to evidence in court. So by doing it by way of emails where there's a timestamp and it's digital, you sort of circumvent that even becoming a possible issue. And you also have sort of almost a journal in your email that is sort of stored for you and contemporaneous. Obviously, when you're in a meeting with your manager, you can take handwritten notes for sure. If you want to sort of put them into this digital journal that I'm describing, you can take a photo of them and email them to yourself. That also would confirm the contemporaneity, whatever, that they're done at the same time as the event actually happened. Another way to sort of confirm that things that were said in the meeting were what were said in the meeting, if you're worried that someone's going to sort of back out on whatever the conversation was, is to send an email after the meeting saying something like, hey, we talked about a lot during that meeting. Just want to confirm that we're on the same page. Here is my sort of summary of what we discussed. Could you just make sure that this looks the same, like that this is your understanding as well? You send it to your boss. They're prompted to respond. If they don't respond, fine. You still have a contemporaneous email describing what you understand happened in that meeting. And if they do respond with something different, you have also like a timely way of addressing that discrepancy. So those are three better ways than recording. I do think that it creates quite a sense of sort of discomfort in employees and employers, and you have to be very, very careful to actually be an active part of a conversation. You certainly can never record a conversation that you are not actively participating in. So like eavesdropping, or even if you're just being spoken to and you're not speaking, you just absolutely do not do those things. My advice is just not to do so. So Ashley came back saying, I was given working notice, but then locked out and not allowed to continue working for the 2 weeks of notice. Okay, so you were terminated and they provided you with working notice instead of severance or termination pay. I wasn't sure if you were saying that you had resigned and given notice and then they had sort of ended your employment early. So I'll talk about both. With respect to working notice, if you were provided it by your employer, and then they sort of decide that they don't want you to continue working during that period, you should certainly be paid for the remainder of the notice period. I'm not, one of the conditions that usually exists with respect to working notice is that you are conducting yourself as if you hadn't been terminated, not destroying company property, like all of those types of things. The concerns surrounding that and things like theft of IP are actually some of the reasons why we see a lot more of pay in lieu of notice as opposed to working notice in recent decades. Because it's a difficult thing to monitor. It's a difficult thing to protect. And I frankly think that it's a better option. I don't think that very many people are thrilled to continue to work for someone who had terminated them. The only time that's not really the case is in the event of something like a business closure where everyone's given working notice for something like 30 weeks. And they just continue to work out until the business closes. Those are kind of the only instances that I personally think working notice seems to be a good option. I think that it can be very complicated to have an employee who, even if they knew or expected or aren't sad about the termination, to have them continue to return to work, especially if there's other employees there. He would know about the termination. It can be an embarrassing, humiliating situation. So Ashley, if you haven't done anything that would amount to cause for termination during that working notice period, so theft and things like that, then you should be provided with pay for those 2 weeks of notice. You could inquire with your employer about that, or maybe wait until the next pay period, because I'm not sure when that would fall for you. But yes, if you were given working notice, you should be paid out for that working notice, except in the event of a proper just cause termination. However, just on the other side of that, if you give working notice to your employer, so you give your 2 weeks notice before you're going to quit, if they decide to waive that working notice period and say, no, you don't have to come back in, they also have to pay you for that working notice. They don't have to pay you. If you give them 6 months working notice, it's not really the same thing. But if you give them sort of the reasonable regular amount, and they decide to waive it, and then they would have to provide you with the minimum of 2 weeks up to whatever it requires of you in your contract, even if you don't work that period, because they are the ones who opted to not have you return. Barbara on Facebook is wondering, is making staff return full-time to the office after working remotely for months a fundamental change? Would it be classified as a constructive dismissal? So this question somewhat depends on the conditions of your employment, the terms of your employment, in your contract or the agreed terms. Really, whether you were working from home or had the option to work from home prior to the pandemic will also come into play. COVID was obviously a unique situation. The world is kind of normalizing again. And if it wasn't a condition or term of your employment that was understood to be fundamental from the outset, or that was understood to have become or agreed to have become fundamental to your employment, you're going to have a challenge making that argument. More likely, your contract requires that you attend work in person, or your offer letter, attend at a certain location or whatever it is. And this was the exception to the rule, out of necessity. So it's going to be a difficult situation to demonstrate. It really depends on why it is that you, it depends in part also on how long you've worked there. If you worked there for 20 years and you were always in office and only in the last year were you working from home, it's not fundamental to your continued employment. If you were hired while it was a work from home situation, it's possible that your understanding at the time of hiring, and the agreed understanding at the time of hiring, was that there would be working remotely or at least partial remote work as part of the contract, or some flexible schedule. So all of those things will come into play in terms of the evaluation as to whether it's constructive dismissal. Generally, I think constructive dismissals where you don't have a decrease in pay or hours or a total change in position. So, you go from being a legal assistant to the janitor, for example, and your salary is decreased by more than 15%. I think those are much harder constructive dismissals to establish and to prove. It doesn't mean it's impossible, but things like commutes can be not the strongest cases. I think if you're being asked to return to work full time in the office after a few months of working remotely, I think you're going to have a very difficult time establishing that that's a constructive dismissal if you ever worked there prior, or if it wasn't agreed in your contract that continuing to work from home would be part of the deal, even if it's not 100% remote. Peter on Facebook asked, if you get fired, are you still able to get EI based on hours from previous jobs, or does the firing negate the opportunity for EI? It depends on the manner of termination. So if you're terminated for cause, and that's the code that's used, then you won't be entitled to EI, technically. However, I always tell people still apply. The worst they can say is no. And I usually recommend that you call Service Canada and let them know sort of what the situation is, that you dispute that the termination was for cause, don't agree with it, and are looking into challenging it and speak to a lawyer about the termination as well. Don't just tell them that you're going to actually do so. Someone in our office can certainly speak to you if that is your situation. The hours you had at previous jobs would still be insurable hours as long as you haven't collected EI in the interim, depending on how far back or how long ago they were worked. There is a time limitation in terms of what time period the hours can sort of come from. Like my job 5 years ago, I can't use those insurable hours, for example. But I mean, the best place to ask questions about EI is generally Service Canada. It's not really something that we have to deal with sort of directly that often. So I would say if you have questions about EI entitlements, to give them a call. But firing does not necessarily negate the opportunity for EI. It depends on the manner of termination and what code is on your ROE. The other thing I'll mention about that is a lot of people are kind of sometimes confused about how ROEs work now. They used to have to mail you a paper copy within, I think, 5 days. Nowadays, they just generally, most of them at least, tend to submit them automatically online to Service Canada. So if you haven't received your ROE yet, your My CRA website login thing is probably the best place to take a look, and it might already be filed. You can apply for EI before your ROE is filed. You just won't be approved for it until the company provides it. But if they are sort of dragging their feet, if you apply for EI will contact them and sort of demand that they get moving on that. So if there's issues with getting your ROE from the employer, that's a good way to sort of speed things along. Mark from Facebook said, the small business I work for has been sold and a new company has offered me a job at the same rate of pay. What kind of severance am I entitled to, if any? So this somewhat depends on what the sort of situation is. If the small business that you work for now has been sold to the new employer and they're effectively taking it over and they're adopting, so to speak, the employees who have previously existed there and offering them continued employment, then you haven't been terminated. In a sale of a business, the employment can continue, but like as the transition happens. If they're offering you a new contract or something new to sign that has potentially different terms than your previous employment did, that's something really to look out for. I would consider, if you have been offered or asked to sign a new agreement, especially if you didn't have an agreement at all previously, that you have an employment lawyer at our office take a look at that contract and discuss what the terms and limitations it might be setting for you could mean for you moving forward. Most often, one of the things that we will see is that you maybe didn't have a contract before, the business is sold and your employment's continued, but the new employer asks you to sign a new contract. And that new contract likely has something like a termination clause that might be newer and more enforceable or enforceable at all in comparison to your previous contract. If there is an enforceable termination clause, and let's say you've worked for this place for 20 years before, you could be giving up all of your severance, the like entitlements from the previous employer in the time that you worked there, even if they say they're going to respect your seniority, and limiting yourself to possibly no more than 8 weeks. The other thing to make sure is that the new contract, if there is one, specifically states that it will continue your seniority for the purpose of all entitlements. But generally, you also don't need to sign a new contract. If it's continued employment, if you're already working somewhere, if you're already working under some other old contract, there's never an obligation to sign a new agreement. And you certainly should have an employment lawyer take a look at it before you decide that you will sign, regardless of what the situation is, so that you understand at least what rights you could be giving up. Rebel from YouTube asked, can employees discuss how much money they're making, and if the employer finds out, is that cause for dismissal, especially if the employer is giving higher pay to employees they favor the most? Nope. The Pay Equity Act requires that you be permitted to discuss, you're legally permitted to discuss your compensation. There are sort of clauses in various contracts that will attempt to tell the employee that they're not allowed to discuss their compensation at any point for any reason. Those clauses are illegal. You can, if you want to, discuss your compensation. The reason being that if no one is discussing it, then there's no way to know when the inequities exist. So the Pay Equity Act makes it so that it's absolutely permissible for you to have discussions. I would, not run around from the rooftops and scream about it. I would have private discussions and keep things as confidential as you can, just for your own privacy. But your employer certainly can't or shouldn't be taking steps against people who are speaking out to one another about that. I think that it's possible they could try, but in the event that you're fired for talking about your salary with somebody else at your workplace, especially if you're terminated for cause, I would absolutely recommend that you call our office and speak to one of our lawyers, because that would be an act of reprisal and going to be a problem for your employer and probably better for you. And this is going to be my last one. Gaurav Grover from Facebook said a friend of mine was terminated this morning. They're giving 1 week in severance and 2 additional weeks if the termination paperwork is signed. Is this legal? I mean, having it structured that way, certainly you cannot be required to sign a termination paper or a release in exchange for your minimum ESA entitlements. So that would be 1 week per year up to 8 weeks of notice and 1 week per year up to 26 weeks of severance in the event that your employer has a payroll of over 2.5 million and has you've been there for more than 5 years. If those two situations exist, then you might also be entitled to the second week. And those amounts you get no matter what. You never have to sign anything for them. So I'm guessing that your friend worked for this employer for less than a year based on the 1 week that they're being provided. And they'll get that no matter what. The 2 additional weeks is the compensation or the consideration that they're providing your friend in hopes that they will sign a release of their right to sue the employer. So they're saying, we'll pay you 2 extra weeks if you release all other claims and you say you don't have any severance entitlements or reason to come after us again, and you actually won't be able to come after us again because you've signed this whole matter is finished. It's usually a good idea to talk to a lawyer before ever signing a release of any kind, so you understand what it is you're signing. Most of them sort of have a provision that speaks to you seeking independent legal advice. So if your friend is interested in speaking to someone, they could certainly call our office and schedule an appointment. The last thing I'll say is there's usually deadlines on these termination paperworks, and employers try to sometimes pressure employees to sign sooner than later. You can almost always ask for an extension, especially if you are advising the employer that you haven't had an opportunity to seek advice. If you've said that and they refuse your extension, they're going to have issues if you decide to challenge the fact that you signed it, because they didn't provide you with the appropriate time and space to consider and to seek legal advice before you signed anything that was legally binding. So if he has to sign by Monday of next week, in all likelihood, very, very rarely happens that if he asks for an extension on that they will very likely grant it, in order for him to have a chance to sort of consider either on his own or to seek counsel. All right, everybody, that's it for today. Our next live stream is with Lior Samfiru, my boss, on Wednesday, February 22nd at 1 p.m. Eastern. And so if you have further questions or I didn't get to you, feel free to join us there. Have a nice afternoon.